Where to even begin when it comes to the prosecution's new bombshell filing in the Sean Combs case? You know why they say he shouldn't be released before trial? While locked up, they allege that he has been trying to improperly contact victims, witnesses, and other people, is trying to taint a future jury, and is employing his family to do his bidding. We got to break all this down and what it means for Sean Combs, and we're going to sit down with celebrity criminal defense attorney Bradford Cohen. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Okay, so there are bombshells after bombshells in the government's new filing in the Sean Diddy Combs case, the sex trafficking, racketeering, prostitution case. I don't need to repeat all the allegations. You know what they all are by now. But prosecutors from the Southern District of New York submitted an opposition brief to Sean Combs' motion for bail that they are hoping that this new judge, in this case, Judge Arun Subramanian, will hear. And as we're going to lay out, prosecutors say not only is Sean Combs not entitled to bail, but essentially he shouldn't even get a hearing on this. And remember, Combs is currently in detention at the Metropolitan Detention Center out in Brooklyn, New York, after being denied bail by other judges. The main issues keeping him locked away are that the courts have held that the prosecutors have shown that he is a danger on the outside. He's a potential flight risk. Most notably was evidence put forward that he had been improperly contacting victims and witnesses in this case. And as we discussed on previous sidebars, Sean Combs' counsel has denied all this. They have indicated that all of those conversations were not done with the intent to engage in witness tampering or obstruction. And even, at least they say, one witness had contacted Combs, not the other way around. Well, the government has come out with new evidence of its own to justify pretrial detention. And let me just read you this from the beginning of their brief. They say, while attempting to evade law enforcement monitoring, the defendant has, among other things, orchestrated social media campaigns that are, in his own words, aimed at tainting the jury pool, made efforts to publicly leak materials he views as helpful to his case, and contacted witnesses through third parties? What? And that's not even half of it, because now we have a better idea of also who may be a key witness in this case. So much to break through, so much to break down. Let me bring on acclaimed criminal defense attorney to the stars, Bradford Cohen, who has famously represented celebrities like Kodak Black and Drake. Thank you so much for coming on, Bradford. I got to start with this bombshell. So the government says, look, you can't let him out because he has already been engaging in obstruction while locked up. They read, the government has reviewed dozens of recordings of BOP jail calls in which the defendant uses telephone accounts of at least 8 other inmates, which is against BOP regulations. Seemingly to avoid law enforcement monitoring, the defendant uses other inmates' PAC numbers to make phone calls to both individuals on the defendant's approved contact list, as well as other individuals who are not on the approved contact list. To obtain or maintain access to other inmates' PAC numbers, the defendant directs others to pay the inmates, including through payment processing apps and BOP account deposits. The defendant also frequently instructs individuals whom he contacts by telephone, including family members and his attorneys, to add other individuals via three-way call. This practice is not authorized by BOP as it helps conceal the identities of the contacted individuals. The government has reviewed multiple calls in which the defendant has instructed parties to dial in third parties, including members and associates of the enterprise and individuals who are not on the defendant's contact list. Bradford, what do we make of this?
Not much.
Really?
So,
Not much?
yeah. So this happens all the time in like every single case. They only make a big deal about it in this case. So the third party calling, when I can tell you in my 30 years, 28 years of practice, third party calling has been done in probably 90% of the cases that I have. In fact, sometimes third party calling to me. So what they would do is they'd get one of their friends on the line, and then that friend would then third party me in. And I always have to tell them, hey, this is an attorney-client privilege. You got a third party on the line. And when you have a third party on the line, anything we say is not attorney-client privilege. Sometimes, and this was really funny, I had a murder case in Tampa where they third partied me in. So it was the defendant calling his friend and his friend calling me. And I knew that the prosecutor was listening, and I didn't
Oh,
give
I
that
remember
warning.
this.
I didn't say,
Yeah.
And then I said, hey, listen, we got evidence that are going to blow the doors off of them. And I knew she was listening, and I wanted to prove a point to my client. And then we went into court, and she's like, "Oh, I heard this conversation with Mr. Cohen. It wasn't attorney-client, and he said he's going to blow our doors off with this new evidence. I want to see this new evidence." And of course, we didn't have that new evidence.
Yeah.
So the third party, I just wanted to prove that the prosecutors, the smart prosecutors, especially in the Southern District of New York, are listening to every single phone call that you make. That's number one. Number two is the thing about using other inmates' numbers. That happens a lot too, because
them getting paid for it? Them getting paid to use it?
Yeah, certainly. Yeah, that happens all the time.
And again, the allegation is not only that, but also contacting people who are not on his contact list.
Yeah, because some people don't want to be on your contact list. Some people don't want to be on the government's contact, because once you're on the contact list, the government now has your name, your phone number. They could tap your phone. A lot of people don't want to be on contact lists. So because of that, they might use, Bob Smith's PAC number and to call their friend, but they don't understand. It goes by the phone number, right? So like if I'm calling from Bob Smith's PAC number, they're looking for the phone number that I'm calling. They're not looking for Sean Combs. So if my number is 555-1212, they could just do a search. Who has called this phone number in the past month? And that's what they do. And then they realize, oh, wait a minute, why is Bob Smith calling this phone number? And then they go back and they listen to the conversation.
Yeah.
Really, what is the biggest thing, the biggest takeaway from this is that when you first get a client, and clients might not listen to you, and he might not be listening to his attorney, and his attorney is a very good attorney. He might have told him this at the very beginning. Right. But at the very beginning of cases, you have to tell them every phone call is recorded. Don't think that you're playing cute when you have PAC numbers and you try to call someone else. They're going to find out. And that's just the way that it is, especially in the feds. So I don't take much of it unless those phone calls are really damning.
By the way, we are not trying to miss any major development in the Sean Combs case, like these legal filings. We got you covered. And I got to call out one of our incredible sponsors who, with their support, helps us to continue to do this. And that is Morgan & Morgan. And here's the thing. If you should get hurt, America's largest injury law firm may be who you want in your corner. Not only over 1,000 attorneys and additional support staff, not only is the process super simple because it can all be done right from your smartphone, not only is there no upfront fee, they only get paid if you get paid, but Morgan & Morgan's track record is incredible, like recent verdicts of $12 million in Florida, $26 million in Philadelphia, $6.8 million in New York, and all of these, mind you, considerably higher than the highest insurance offers in these cases. So if you're injured, you can easily start a claim at forthepeople.com/LC sidebar. Well, what about, they say, quote, the defendant also uses a non-authorized third-party messaging service called Contact Me ASAP to obscure his communications. The defendant appears to be using two Contact Me ASAP accounts. First, the defendant's BOP contact list includes a particular email address assigned to the defendant's son, which does not appear to be an account owned by the defendant's son, but instead appears to be an email address connected to Contact Me ASAP. Second, the defendant appears to be using another inmate's Contact Me ASAP account, primarily using email one. The defendant has exchanged hundreds of text messages via Contact Me ASAP with dozens of individuals, including attorneys and individuals who are not on the defendant's contact list. So any issue there?
Again, if he's contacting his attorneys, it's usually, it always is attorney-client privilege, unless there's a third party involved. Some people don't feel comfortable talking to their attorneys on jail calls, even though they know they're not supposed to be listening to those calls. I can tell you, they do listen to some of those phone calls. They're not supposed to. They might not use it in a court of law. But a lot of times you find that oh, sorry, by accident, I didn't realize it was his attorney until I was 3 minutes in.
Right.
So I don't take much of that unless, like I said, unless they have some damning evidence that he is doing something crazy on those phone calls, or he's doing something crazy on that application. Other than that, just using it doesn't really speak to a lot.
I guess the counter argument would be, putting aside what the content is, we'll get to that. If he's breaking the rules of the prison, right, this is not the prison, if he's breaking the rules of the detention center, should he be on the outside? Is he going to flout the rules of his bail? That would be the argument.
Yeah, I mean, that's a better argument, but the problem is that, quote unquote, breaking the rules by making phone calls and things of that nature, unless those phone calls are the prohibited thing. Like if I am calling a witness directly and having direct witness contact by using this kind of obscure messaging and things of that nature, yeah, 100%. But I
Okay.
think just because he uses third-party calls, that's like, like I said, 99% of the cases do that.
Okay, so let me there's just so much to get to, so I want to get through everything with you. So this is the prosecutors
Sure.
have indicated that they will produce these calls to Combs and his lawyers through a filter team prior to what is a scheduled bail hearing on November 22nd, 2024. We're going to be covering that on Law and Crime. But then they write this. On multiple calls, often using the PAC numbers of other inmates, the defendant is explicit about his intention to use public statements to alter public perception, and the defendant leaves no doubt that the narrative he wants to leave is the potential jury pool's perception of this criminal proceeding. And examples of these efforts, they say, are plentiful, and then they black out and they redact all of those examples. First, Bradford, why the redactions?
Well, the redactions probably because they don't want it to then make it public what his position is. Like, I didn't do it. This one witness, she did X, Y, Z. I'm sure that there's things in there that the government doesn't want the public to hear because the government has their narrow view of what's going on, right? And whenever the defendant then wants to address that narrow view and put out his own statement or address it in a different way, they want to curtail that because they have a certain way to look at a case. They don't want anyone looking at it differently. I find this to be the most ironic thing. It's like it's hypocrisy at its best because although the New York Southern District office does not themselves leak things often, they have in the past, but in this case, I don't think there's any evidence that they leaked anything. They also know that other individuals are leaking things that help their case, and they're not curtailing it. Like the video of Cassie was certainly leaked. My guess is it was her attorney who leaked it. I don't know for sure, but I would guess that it would be her attorney who leaked that video because that video was in their possession, and that video is something that helps her case to say, hey, I'm not a defendant. I'm a victim here. I will guarantee that the government knew that video was in their possession and that the government knew that some individual was leaking that. And they could have found out who leaked it, but they don't care because it helps their case.
That's what Combs' attorneys have been saying. Yeah, that's what Combs' attorneys have been saying.
Yeah, and if it didn't help their case, 100%. And if it didn't help their case, they would then be curtailing it.
Well, here's a specific example that's not redacted, that's not blacked out about what they say happens. Because they say after the court entered a gag order, by the way, to not disclose information about the case that applies to the prosecutors, investigative teams, law enforcement, but it also includes Sean Combs and his attorneys. The prosecutors write, the defendant enlisted family members to plan and execute a social media campaign around the defendant's birthday with the intention of influencing the potential jury in this criminal proceeding. And by the way, we covered this on Sidebar. We played that video for you where you can hear his kids wishing him a happy birthday. Combs is on the other line, seems to be happy. But the prosecutors write, at the defendant's carefully curated direction, the defendant's children posted a video to their respective social media accounts showing the defendant's children gathered to celebrate the defendant's birthday. The defendant, from within the MDC, the Metropolitan Detention Center, then monitored the analytics, i.e. audience engagement, and explicitly discussed with his family how to ensure that the video had its desired effect on potential jury members in this case. Bradford, is that a stretch to say that this is tampering with the jury? Or could they say, hey, look, we're just trying to show positivity to change the public perception about him? What do you make of that allegation?
Yeah. I make very little of that allegation. Again, I think that, when you're in this situation and you can put out some PR that makes you look better than what they're saying. And listen, he's done a lot of good. It's not like he hasn't done good in his career. He has done good in his career, pointing out the good things that he's done in his career, pointing out that it's his birthday, pointing out that he's got a bunch of kids to quote unquote affect the potential jury pool. There is no jury yet. The jury pool could be from Staten Island. It could be from, Manhattan. I mean, the fact is that anything you put on your social media could affect a potential jury pool that we have no idea where they're pulling from, and we have no idea who they are. I think it's a huge stretch to say that would affect a jury pool. Would I think that it would affect perception of Sean Combs? Sure. And what's wrong with that? He's not talking about the case. It's not a gag order on happy birthday to Sean Combs. And it's not a gag order to say, hey,
Well,
at one point he gave, $50,000 to St. Jude's Hospital. That's not the quote unquote gag order.
So let me push back on that a little bit because,
Sure.
and this was something that I wondered because his son had taken over his Instagram and was posting videos of his father's music videos and behind the scenes footage, and I was curious at the time about what the purpose might have been. But this is what prosecutors say in their filing. The defendant's own words make clear that his intent is to improperly influence the jury pool in this criminal proceeding. During other calls, the defendant makes clear his intention to anonymously publish information that he thinks will help his defense in this case. And then there's a portion that is redacted, but it also continues. The defendant's efforts to obstruct the integrity of this proceeding also includes relentless efforts to contact potential witnesses, including victims of his abuse, who could provide powerful testimony against him. For example, on October 4th, 2024, in a call involving the defendant and one of his adult sons, the defendant says, and then again, it's redacted, and then they write, provides the clear inference that the defendant's goal is to blackmail victims and witnesses either into silence or providing testimony helpful to his defense. So Bradford, in other words, they're saying, A, they have him on tape saying, I want you to put forward this social media content to help my defense, and B, communications about him trying to reach out to people in the case and maybe using his family? Now, what do you think about that?
So those are two different things. The first part of it about him reaching out about social media, I don't put much weight into it. I think it's something that every defendant that's popular will do. It's something that every defendant that is popular has done. When you have these allegations, and there's certain allegations that this guy's a bad guy, you're going to have social media saying that he's a good guy. And whether or not it is orchestrated by the defendant or orchestrated by a PR team, it makes no difference to me. The second part of that, if he's trying to reach out to witnesses, that's the part that, obviously is probably their strongest argument, right? If they have witnesses that are willing to come in or people that are willing to testify to say, hey, listen, he gave me XYZ in order to say XYZ, that's completely different. I don't think they have that, because if they did have that, I think they would be charging for every single witness that he has tried to do. The government is not just going to sit back and be like, oh, he paid that guy, we're not going to charge him for that. They're going to charge him for every single little thing that he has done or has attempted to do. So they, just not one count of obstruction. They could hit him with 10 counts of obstruction for every witness. I just don't know if that's what they have. I don't put a lot of faith in the allegations from the government when I have seen in my career those allegations fall short of what they're actually saying in those documents.
And I guess if they don't charge his family members or people that, he's charged with racketeering conspiracies, accused of reaching out to alleged co-conspirators too. If the government doesn't charge any of those people, what does that tell you? And by the way, should we anticipate charges against, family members if this is what's happened, if this is what the government's alleging?
If the government actually has the goods on this obstruction, then there would be no reason not to charge them. But the problem is that I don't think they actually have the goods. I think that what they're really looking at is that individuals might have reached out to him to say, hey, listen, this XYZ happened to me. I'm going to file a civil lawsuit. I'm demanding $50,000. And it could be that they're settling civil lawsuits, and the government always feels when you settle a civil lawsuit that is under the guise of buying off a witness. That's always been their position. Doesn't matter what case it is, doesn't matter who you're representing. If there is a civil lawsuit that is pending or a civil lawsuit that could be filed that a potential witness says, hey, I want to settle and I want XYZ amount of money, and you give it to them, the government's position is always you gave it to them to buy their silence or to change their testimony. That's just the way that it always is in every case that I've ever had, and in every case that I've ever read about in terms of federal witnesses that also file civil lawsuits.
Bradford, I got to ask you about this part, because prosecutors say, they write this, quote, then after the defendant was in custody, BOP investigators recovered the following notes from the defendant's cell during a pre-planned nationwide sweep of BOP facilities. The The strong inference to be drawn from the defendant's communications with witness 2, and I'll explain later on who that is, and his personal notes is that the defendant paid witness 2 after she posted her statement. So Bradford, first, we had reported that there was this sweep by the feds of the MDC, and maybe those notes were a part of what they discovered. But then Sean Combs' team has just responded in their own filing today, and they write, defense counsel has recently learned that the prosecutors are in possession of attorney-client privilege material, including the defendant's own written notes. This search and seizure are in violation of Mr. Combs' Fourth, Fifth, and Sixth Amendment rights. Moreover, the targeted seizure of a pretrial detainee's work product and privileged materials created in preparation for trial is outrageous government conduct amounting to a substantive due process violation. Because the prosecutors are currently in possession of privileged material and are actively using this material to detain the defendant, the defense requests an immediate evidentiary hearing. Two sides to this, Bradford. What do you think?
I side with the defense. As usual, I side with the defense. Not always, but in this case, to me, it really is outrageous that they're using his notes. And if it's work product, which I believe that it is work product, I don't think they should be able to. Think about this. They're going into cells and they're looking for usually weapons, illegal items, things that you shouldn't have, phones, cell phones and tablets, things that are snuck into the jail, drugs. And here he probably has a pile of paperwork or notebooks, and they start going through each notebook and reading them and determining whether or not these notes should be used against them in a court of law. It really is one of those positions where why you don't want your client in a jail situation, why you want him bonded out, because while he's in jail, if they can just do this, how do you contact your client? How do you give him paperwork? How do you give him certain things from your law office? How does he take notes to discuss with you the next time he's going to see you when you come to the jail? So he's taking notes in a notebook thinking like, this is what I want to discuss with my lawyer. And then they seize that and they go through it and they use it against you. I do think it's overreaching. I think that there is some case law. The only thing that I'm worried about is if they say this is some sort of crime or a crime fraud exception where the notes themselves are making reference to, obstruction or something like that. They could try to make that argument, but it's really a bootstrap argument because what they're saying is we seize the notes first and then we determine that they could be crime fraud exception. That's really the problem. It's not that they knew they were a crime fraud exception and they seized them afterwards.
Right. So just to be clear about everything right now, first of all, before I let you go, because Bradford has to go, but we have more of this to go through, I wanted to ask you big picture about this. Not necessarily whether everything we've talked about so far is about whether he's going to be charged with an additional crime. It's about whether or not he is entitled to bail. And that's the main issue. Based on these allegations put forward by prosecutors, and yes, it's a lower standard than we're talking about in a kind of a criminal case about a conviction of with a criminal charge. Do you think prosecutors could potentially meet the standard that he should not be released?
Yeah, I mean, listen, in federal court, it's very difficult to get bond on any case. Even the cases where you're somewhat entitled to bond, it's still hard to get because these prosecutors come in with these allegations, and no federal judge wants to give someone the opportunity to flee or to influence a witness or to do things. So a lot of federal judges, they don't want to stick their neck out if they don't have to, and if the law is on their side and there's some discretion there. In these cases, it's up to the defense to show why he should get bond, to show how he should get bond, and to put forth a bond package that's acceptable to the court. So my guess is I don't think he's going to get bond on the third try either. And I think it's a very low standard where the prosecutor can show, unless the defense is coming with something phenomenal, it's a very low standard for the prosecutor to show, hey, listen, this guy shouldn't get bond because of X, Y, and Z. All they have to really do is make the allegations. Even with a hearing, you usually have someone come up there and say, oh, look, he's making third-party calls, and they make a bigger deal of it than it is. And generally, they don't get bond. So I would say there's a 98% chance he doesn't get bond.
I agree with you. I will be very curious to see these arguments laid out. I imagine defense counsel will make a lot of the arguments you have just made. This is why you get paid the big bucks, Bradford. This is why we have you on. Love talking to you. Sorry it took so much of your time. Really appreciate it. Bradford Cohen, everybody, thank you so much.
Thank you.
Okay, so I want to continue this. Obviously, Bradford's so generous with his time. Appreciate it, but a lot more to get to in this filing. So prosecutors write, since being in custody, the defendant has deployed family members to carry out obstructive conduct on his behalf, as evidenced by jail calls. The defendant asked family members to reach out to potential victims and witnesses, create narratives to influence the jury pool, and pursue marketing strategies to sway public opinion. So that's what we talked about before. This next part is fascinating because I think we may have an idea of a potential key witness in this case. So the prosecutors, they address Combs' claims that his contacts with any potential witnesses were innocuous. Prosecutors say, no. They write, the defendant also claims that the defendant's contacts in September 2024 with an individual represented by counsel who wanted to make a public statement, witness 2, were not in any way obstructive because the defendant and witness 2 were previously in frequent contact. However, the contact between the defendant and witness 2, who were bandmates, stopped in March 2024. And from the timeline and the context of the defendant's contacts with witness 2, it is clear that when the defendant reinitiated contact with witness 2 in September 2024, his purpose was to ensure that witness 2 was on his side and to pressure witness 2 to make a public statement denying allegations of violence by the defendant. The defendant reached out to witness 2 on September 11, 2024, and sent her a copy of the lawsuit against the defendant in which witness 2's name was mentioned several times. The defendant then called witness 2 and they spoke for nearly 6 minutes. After reading the lawsuit, witness 2 called the defendant back at his request and they spoke for over 4 minutes. Evidently, the defendant and witness 2 discussed witness 2 drafting a statement, as immediately after the call, the defendant told witness 2 in a text message, and then that's redacted, but then they go on to say, from September 11, 2024 through September 15, 2024, the defendant and witness 2 exchanged multiple texts and had multiple calls, at least 128 phone contacts in total. Witness 2 ultimately made a statement about the lawsuit via an Instagram post on September 13, 2024. Now, a couple things to break down here. If these allegations are true, this was right before Sean Combs was arrested. So if you're prosecutors and you think that he's reaching out to potential witnesses and influencing what they're saying, that is an argument for why they needed to jump in and arrest him immediately, and now are saying why he doesn't deserve to be out on bail. But I think we know who witness 2 is, because witness 2, these allegations seem to be in line with Kalina Harper, who was in the musical group Dirty Money with Sean Combs and Dawn Richard. Dawn Richard filed her own lawsuit against Sean Combs. And we know that Kalina Harper on September 13th wrote this on her Instagram. I acknowledge the recent lawsuit filed by Dawn Richard in which my name has been mentioned 33 times. While I fully respect Dawn's right to recount her experiences, I want to emphasize that her account reflects her personal perspective and should not be interpreted as a universal truth applicable to everyone involved. So again, that seems to be consistent with what prosecutors are saying. Does that mean Kalina Harper is going to be a key witness in the criminal case? Maybe. Now, I want to finish up with some more arguments from prosecutors here. Like, for example, they say the defense hasn't presented any new information or evidence to justify bail. And they also say, and I think this one is key, we're rejecting Combs' defense that he deserves pretrial release because he can't prepare for trial. They make the argument, look, the MDC, it has provided him with more than reasonable accommodations to meet with his lawyers. He can meet with them 7 days a week. He has access to a separate conference room. He can talk with them by telephone and written communication. And saying, oh, there's a lot of discovery in this case. You can't properly review it in the MDC. They don't have the proper conditions. They say that argument is inadequate. And they also make the point, look, if Sean Combs needs more time to prepare for trial to review this evidence, then guess what? He should request an adjournment of the trial date. He was the one who wanted this trial so quickly, which is currently scheduled for May of 2025. That's a good point. I would imagine if I had Bradford Cohen on, he would disagree with me, but I'm sure he would talk about the conditions at the MDC, which are absolutely horrific. But look, the prosecutors say that shouldn't be a reason that he should be granted pretrial release. Now, I also want to highlight where they mention victim 1. Because we believe that is Cassandra Ventura, potentially the key witness in this case. And this is Combs' ex-girlfriend who filed her sexual assault lawsuit against him back in November of 2023. arguably, by the way, starting the ball rolling on all of these lawsuits facing Sean Combs, the criminal charges. But here, prosecutors were fighting back against this argument from the defense that the text messages will show that their relationship was just tumultuous, it was toxic, that what you're seeing here is not an example of a freak-off or sex trafficking or anything illegal, because obviously there's been a large back and forth where prosecutors say, you want a prime reason why Sean Combs shouldn't be released? Look at the 2016 video of him purportedly beating Cassandra Ventura in a hotel hallway that was published by CNN several months ago. The defense has said that's not an example of her trying to escape a freak-off. This is a really unfortunate domestic spat. It's not examples of sex trafficking or racketeering. That shouldn't be used against him for why he should be locked up. Well, prosecutors write, not so fast. Quote, the defendant cherry picks to paint a misleading picture, ignoring numerous other messages in the record between the defendant and victim one, documenting the defendant's physical abuse of victim one and his threats to expose recordings of freak-offs. And of course, again, the freak-offs are the central claim of this criminal case, these coerced, prolonged sexual experiences where people were forced to participate. There was threats, there was violence, there was an exchange of money, sex workers, transporting the sex workers across state lines. But this is where the prosecutors say, they say, we have text messages to show this is more than what the defense says. There's a text message reading, you know what sick and disgusting S I was reminded of the other day? You forcing me to blank, or you were going to leak some S. I have a black eye and fat lip. You are sick for thinking it's okay to do what you've done, and I still have crazy bruising. I turn my head for a second, and you get effed up, and you drag me down the hall by my hair. I have bleeding cuts. You hit me in the head 2 good times. Again, I think Cassandra Ventura is going to be a key witness, if not the star witness in this trial. And putting their relationship on the focus, these messages, this back and forth will be, I think, a really, really big component of it. Now, going to one final point, it's interesting because prosecutors say the bail package that Sean Combs and his defense attorneys have put forward is inadequate. $50 million bond, home confinement with 24/7 monitoring by private security, only having visitors be family members, no internet service, no telephone service. They say it's all not sufficient. Why? Because they're alleging he deployed family members to engage in obstruction, that he can always get people, this is what they say, to do his bidding. Prosecutors say, quote, he can always get people to do his bidding, like employees, family members, MDC inmates, private security personnel. They wouldn't be immune. So again, really interesting arguments put forward by the prosecution. We'll see what the defense response will be. Saw a little bit of it talking about the notes, and this was a violation of his constitutional rights. But I'm waiting to see what happens at this hearing on November 22nd. Should be fireworks. We're going to do our best to cover it for you here on Law and Crime and Sidebar. But until that time, that's all we have for you right now. Thank you so much for joining us here on Sidebar. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.